Good morning, everyone, and thank you so much for joining our webinar on geopolitical risk and contractual exposure. We're doing this webinar in partnership with Dada Muhammad and Moncton Chambers, as well as the other business councils in Kuwait. So we thank you for taking the time, and we thank each of their members for taking part in this great discussion. Our moderator for today is Ahmed Wagie, Legal Strategies and FDI Policy Advisor at Kadipa. So, Ahmed, the floor is yours.
Thank you, Paula. Good morning, everybody. And thank you for having us today. And welcome everyone today. Recently, geopolitical developments are creating uncertainty for companies operating across international market. Businesses may face contractual disruption, supply chain delays, payment restrictions, and regulatory exposures. Companies operating in Kuwait and Gulf often rely on international contracts, and many of which are governed by English law. As a result, geopolitical events may raise complex legal questions regarding contractual obligations, force majeure, sanctions exposures, and dispute risks. This webinar aims to provide practical guidance for businesses mitigating these challenges. The session will combine for regional legal insights from Kuwait, English law expertise from London, practical guidance for in-house counsels and commercial team. And I will start to introduction my guests today from Kuwait, Dar al Muhammad, Mariam Al Failakawi. Mariam Al Failakawi is a lawyer. She advises in commercial and civil matters, arbitrations, dispute resolutions, legal advisor work, and preparation of contract and agreement. She's also experienced in analyzing complex legal matters and supporting clients with practical and effective legal solutions. From London, Mackinton Chambers, we have Drew Holliner. Drew Holliner is a barrister and international arbitrator at Mackinton, with practice focused in international arbitration, geopolitical risk, energy, shipping, and sanctions related to disputes. He is admitted in the UK, US, Ireland, and Russia, making him particularly well placed to advise and act complex across border matters involving overlapping UK, US, and Europe Russian sanctions regimes. He has substantial experience across the wider Gulf regions and sat on the panel of arbitrators of the IFC and Center and Saudi Center of Commercial Arbitration. Also join us from Mackinton, Francis Horbiol Strickland. He's focusing on commercial litigations and international arbitration. He maintains a broad practice across international trade, civil fraud, energy, and procurement disputes. In 2025, he's shortlisted for shipping commodities and aviation junior of the year. Also, we have Iwan West, KC. Iwan West has a wide-ranging practice covering computation, commercial, procurement, public and regulatory law as a former of UK governmental official. He has practical interest in cases at intersection of the public and the private sector. He is also called to the Bar of Ireland and registered at the FC Court. Welcome, everyone. Before we get into the discussion, I think it worth to recognizing how quickly the situation has evolved over the past month. What we are seeing is not just geopolitical development, it's something that is already translating into real contractual and commercial pressure for businesses. And that really is the lens for today's discussion. I used for a long time ago to participate, to register myself to all clients alert all over the law firms, consultants over the world. But during the last circumstances, I received an advisory note from my email from Dar Muhammad. Advisory note about what situations happen. This is not the regular advisory note that I usually read as a house counsel, but I feel it is a very good start that we could start with. And that's why we're inviting Dar Muhammad and Mari. This is a conversation about how legal risk is actually unfolding in real time for businesses. Mariam, welcome aboard. And Let me start from you. Um, Business reality here in Kuwait and Gulf. We have seen rapid escalation in region over the past month, rising immediate concern for businesses around contractual exposures. This is something Dr. Mohammed addressed in its recent advisory note. Uh, I want you today to shed light about your approach about what should companies doing now before disruptions turn into a legal problem.
Thank you, Amr. So, from our perspective, the first legal step is not to wait for a disruption to become visible in operations. It is to immediately conduct a structured contractor risk. In practical terms, I'll say starts with the identifying contracts that are most sensitive to current developments, especially contracts linked to supply chains, financing, guarantees, and critical performance obligations. So, not all contracts carry the same exposures. Companies need to know from very early which relationship are vulnerable, which obligations might become difficult to perform, and where the legal pressure points are likely to emerge first. So, the first move is really contract mapping and prioritizations. I believe if management has that picture, it can make better decisions on escalations, not builds the communication. So, in short, let me say before discussing brand is business needs to support.
That's very helpful and practical way for looking at it, Mariam. What comes through very clearly is that the issue is not just the event itself, but now quickly but quickly how carefully businesses respond for a contractual perspectives. Francis, let me bring you in at this point. That's very what comes through very clearly is that the issue is not just the event itself, but how quickly and how carefully businesses respond from a contractual perspective. So, when situation escalate this quickly, many businesses often start asking whether this already a force majeure situation. So I want to be from your perspective, in your view, how should that question really be approached in practice under English law?
Thanks, Amir. Yeah, it's a good question. I think from an English law perspective, my advice would be the first question isn't, is this a force majeure event? It's, what does the contract say? And I say that because English law doesn't recognize a freestanding force majeure doctrine, unlike the position in, say, France or the UAE or Qatar or Kuwait. I think it's Article 215 of your civil code. So the proper starting point from a contract governed by English law is whenever someone rings me up, is to look at the contract, look at the specific clause, and read it with forensic care. Although force majeure clauses differ, there are normally some similarities in the way they're drafted, and ordinarily you need to satisfy at least four things. The first is to check that the event falls within the contractual definition of a force majeure event. Second, that there is a clear causal link between the event and the failure to perform a specific obligation. Third, that the event was beyond the affected party's reasonable control. And fourth, that reasonable mitigation steps had been taken. And of those, the most consequential drafting point, and the one people often overlook, is the threshold of interference. So a clause requiring performance to be quote unquote prevented sets a very high bar. It's essentially physical or legal impossibility. By contrast, a clause requiring only hindrance or delay imports a materially lower threshold. So, and that single distinction can be the difference between winning a case and losing one. So essentially, my advice is look very carefully at the contract and the threshold test first.
Oh, that's very helpful, Francis. Especially the point that not every disruption automatically gives rise to the force majeure, and that is answer really depends on the wording and contractual framework. But in many cases, the issue doesn't stop at the performance. Drew, let me bring you in here, please. In practice, what we are also seeing is that disruption quickly spills over into payment, counterparties, and the cross-border obligation. Sanctions can quickly move from a compliance issue into something much more complex. From a dispute perspective, what do you see as the real pressure points emerging first?
Yes, well, I'd say the first point I would make is that, inside companies, often sanctions are addressed as a pure compliance issue. Can we do a transaction or not? But when we're talking about disputes, that's usually where the hard questions begin. So often the first real pressure point starts and one party says, I cannot perform this obligation because of sanctions. And the other says, no, actually, you're using sanctions as an excuse here. That has now become a very familiar pattern in disputes and arbitration litigation around the world. And sanctions are increasingly being used as a merits defense in situations where they may not even directly prohibit performance at all. I was recently involved in a lengthy arbitration where the entire issue came around whether the risk of being placed under sanctions by a particular country was sufficient to prevent performance, arguing on principles of good faith and so forth. So the first task in any dispute is to sort of strip away the sanctions rhetoric and ask some very basic but important questions, and that is which sanctions regime is said to apply in this case? What is the connection with that regime? What exactly is prohibited? And what does the contract say about it? So we're seeing a sort of common theme here. And the reason for that is because of the way sanctions have developed. In the past, sanctions were usually imposed unilaterally or multilaterally at the UN level. But what we've seen is a proliferation of unilateral sanctions by various different governments or governmental groups, US, EU, UK are very significant jurisdictions, but they all, unhelpfully perhaps, they all have different ways of addressing these issues. They may have different licensing requirements. They may have different designated parties. So in every specific case, you may have not only multiple touch points on sanctions issues, but each of those governments and regimes deal with the issues differently. And that's not to mention situations where you actually have them at conflict with each other, as we're sort of aware of the EU blocking statute, sort of in respect of Iran. We're seeing a lot of sanctions and counter sanctions involving Russia. So the legal answer to any sanctions question is going to depend on things like nationality, residence, currency, how the payments are routed, and the place of performance.
I see.
Just a good example of this is a recent case in the UK Supreme Court called RTA and More Shipping, where the dispute was not just about whether parties are under sanctions. It was agreed that the parties were not under sanctions, but the contractual mechanism to payment was routing US dollars through an intermediary US bank account. And the question is whether a force majeure agreement clause requiring a party to take reasonable measures required them to accept payment in a different currency to comply with the sanctions, so the sanctions wouldn't bite on it. And the Supreme Court held it did not go that far as to require a party to accept performance that was not required under the contract. So these are sort of the main pressure point is the sanctions sort of enter as a regulatory issue, but they quickly become a contractual and evidential issue. And that's why we really need to look at the contract and the facts in each particular case.
That's extremely helpful, Drew, especially the point that the sanctions risk can very quickly become a dispute risk, sometimes even before a formal dispute arises. So we have looked at the contractual disruptions, force majeure, and sanction-related pressure. Iwan, let me bring you in at this stage. Stepping back slightly and looking at this from a broader English law perspective, how should businesses be thinking about contractual risk and decision making in long-term arrangement when faced with this such kind of uncertainty?
Thank you, and good morning, everybody. Well, obviously, there's always the danger that when you're looking at contracts, that you're sorting out the problems that arose in the past, and there will doubtless be a lot of learning that will take place as a result of the current situation, which will need to be factored in the future. But when you look at the current situation, I mean, clearly, to reiterate what both Francis and Drew have said, you're inevitably forced to look at the documents you have and that you have signed and you have contracted to, because the contract is going to be the beginning of the analysis and may in fact end up being the end of the analysis. But it's just important to bear in mind that, of course, there are various English common law doctrines which can be brought into play potentially. And sometimes the issue may in fact be deciding which of these, which one or more of these you want to rely upon, because they are not necessarily all capable of being run at the same time. But for example, and we'll come to this later, you looking beyond the contract, you're looking at considerations that are wider, that specifically are not in the contract, because if they were in the contract, you'd have to operate them. So we look, for example, in particular to doctrines such as frustration, such as illegality, and then also potentially, even when you're looking at the contract itself, you're going to be looking at things like the Braganza duty in terms of how contractual discretion might be exercised. So the important thing is to be able to think, both focus on the contract, but also focus beyond the contract on these wider considerations and how they may work. And that's something I'll say a little more about in due course.
That's very helpful, one. Focus beyond of the contract. But managing legal risk here is not just about understanding the law, but about how decisions are made in practice. But we often see in that real exposure, it's not always where businesses expect it to be. Marshall, let me come back to you here. From your experience, which contractual provisions are most critical to review at this stage? And where do companies most often miss the risk?
Often the first provision I would look at, of course, personally, and hardship clause, but I would not stop. Well, in practice, we often see companies focus only on whether an event fits within first measure, while missing out on important provisions such as notice requirements, timing obligations, material change clauses, or even repricing mechanisms. Notice provisions are especially important. In many cases, the legal issue is not only whether a party had a valid basis to rely on a clause, but whether it complied with the contracted procedure and the deadlines of doing that. I would also say a business should review whether the contract gives them any flexibility short of formal relief. For example, if it's with them in the negotiation triggers their pricing rights or material advice to interrupt that. So the exposure, I'll say, it's often missed it's not missed in the headline clauses, but in the surrounding mechanism of the contract.
I like this point. That's very helpful, especially the point that the risk is not often hidden in how the contract actually operates in practice, but even where the clauses are there. We often see mistakes in how they are used. So, if we take that one step further, Francis, where do businesses most commonly get this wrong when dealing with force majeure or disruption situations?
Well, thanks, Amir. I think two failure modes dominate generally. The first is treating force majeure as an operational judgment rather than a strict contractual exercise. So to take an example, let's say you have a senior executive who looks at the fact and says, oh, this is obviously force majeure because there's a war on, and a declaration goes out. The problem is that the English courts don't assess force majeure on those terms. The correct question is whether the precise contractual wording is engaged on the present facts. So using the example I gave before, under a prevention clause, if a seller who's shipping cargo is able to reroute that cargo, however costly, that will normally defeat an argument that there's a force majeure event because performance wasn't impossible. It was just a lot more expensive. The second failure mode is one that Mariam's already touched on, which is premature or misjudged declarations. So a force majeure declaration that turns out not to be justified, if it's worded badly and a party who's attempting to rely on it says, I have no intention of performing, that can, in certain circumstances, itself amount to a repudiatory breach of contract, giving the counterparty the right to terminate the contract and claim damages. So in those circumstances, there's a risk that the party that thought it was protecting itself ends up actually being exposed to a much larger claim. So my advice would be very careful before evincing an intention not to perform. And alongside that, I think a third point, in sectors like shipping, commodities, energy, parties often default to the force majeure clause when another contractual provision might be a better tool or an easier tool to use. For example, a war risks clause or a safe port warranty in shipping, or a change in law or a sanctions clause. Choosing the wrong vehicle can waste better defenses.
That's very helpful, Francis. Especially the point that the issue is often not the absence of the clauses, but how they are understood and used in practice. But even where the contractual position is understood, we often see risk coming from outside contract itself. Bruno, let me bring you in here. Where do you see sanction risk most commonly being underestimated? And also want to know your opinion about how does it begin to surface in disputes?
Yes, well, I'd say the biggest thing that where when companies tend to underestimate or management tend to underestimate is by looking at sanctions as a binary question: is this sanctioned or not? When in reality, the dispute often lies in the gray areas around sanctions, and that works both ways. So, first is a situation where there is no obvious prohibition on a counterparty or a particular transaction, and concluding that there's no serious problem, because often these things can give rise to problems before anyone can point to any clean statutory prohibition. This is because the payment chain might become unstable because of banks being not willing to deal with the risk. Insurers may not be willing to touch the transaction if it's too close to a sanctions risk. Service providers might be reluctant to get involved. There can be sanctions on a vessel that's being used to transport goods, and other intermediaries may refuse to get involved. So these are all commercial issues, but not necessarily sanctions issues, but they are generated by sanctions. And that will, again, often come down to whether you have a defense or not, is what your contract says about those commercial risks. And that's why one needs to plan for it. I'd say another thing is one tends to underestimate that if the party or transaction does come under sanctions, there is a prohibition, assuming that offers a full defense. Because we've seen cases, examples in the English court, in the Iran sanctions case called Maran Cochet, where an insurer decided not to insure a transaction because of sanctions risk, but the court or withdraw from that transaction, and the court did not allow it to do so on the basis that it was only a commercial risk and not an actual sanctions prohibition. On the other hand, we've seen situations where there is sanctions imposed, but there is a licensing regime available. So there's another case in the English High Court called San Juan Corporation, where we've
Yes.
seen that the court decided that the party had to apply for a license as part of its duty to exhaust that before they can rely on a sanctions defense. And I just say finally, the other issue would be enforcement. So obviously there are parties that impose, or the governments that impose sanctions, but a lot will depend on where you're going to hear your dispute, or it's going to be enforced, and how that jurisdiction deals with sanctions. As we've seen with the recent Russian sanctions, they've adopted laws to attempt to claw disputes back into Russia, where it involves a Russian sanctioned party, and that's led to lots of collateral litigation around the globe, where you can even arbitrate the dispute. So those are all things that we have to be aware of in the current environment.
That's very helpful, Drew. Particularly the point that the sanctions risk often develops in a way that are not immediately visible at the contracts level. So if we take that on a step further, even where force majeure may not apply, we often see businesses needing to consider a wider set of legal concepts under English law. Iwan, let me bring you in here. From your perspective, how should companies be thinking about issues such as frustration, illegality, or changes in circumstances? Because under English law, when the contract itself does not provide a clear answer.
Thank you. Yes, I mean, there are, coming back to where we're all in agreement. I mean, obviously, the first thing you're going to look at in your is you're going to look and see if you can get yourself within the scope of some contractual clause, such as if there's a material adverse change clause, if there's a change in law clause, that may assist you. But I'm assuming for present purposes that none of that arises. So you have to look at this wider tapestry. And I think there are really three limbs that you could consider, none of which is straightforward, but all of which are arguable, and particularly in a dispute, when you're trying to resolve something through a dispute mechanism before getting into formal litigation. They're all considerations you would want to take into account. The first of those is frustration. Frustration, of course, is very difficult, and it's only going to be relevant when there's no force majeure, or where there's a force majeure clause that clearly doesn't cover the event. So it's something because it requires a supervening event, which precisely has not been the fault of either party, nor has it been properly taken into account in the contract. So it therefore, by definition, is something that the parties haven't considered. But the difficulty is what it has to show is that performance has to be impossible, illegal, or radically different from what was envisaged. And the case law on frustration sets a very, very high hurdle. We do, interestingly, have some parallels with the current situation in the Gulf region, because, of course, in 1956, when the Suez Canal was closed, that was an event which gave rise to claims of frustration. And in that case, there's a case of Sadhguru and Noble Thal. In that case, the House of Lords actually held that frustration didn't apply because the closure of the Suez Canal didn't frustrate a sale of Sudanese groundnuts, because the goods could still go around the Cape of Good Hope. Now, obviously, going around the Cape of Good Hope will cost a lot more money, but it was not impossible to perform. The difference, it seems to us, is that the closure of the Strait of Hormuz may actually be different because there may be no alternative to using that, in which case you may have an ability to argue a frustration. Of course, the point about frustration is it brings the contract to an end. The parties are released from their future obligations. And then not only are they released from their future obligations, they're not even suspended. You don't have to come back. So if the Strait of Hormuz open, if you can show the closure of the Strait of Hormuz is a frustrating event, and you can terminate on that basis, then when the strait is reopened, you don't have to reignite the contract. So you can see immediately why frustration has to be taken very strictly, because it could be used as a means to get out of a contract which in practice had proved for completely different reasons to be ones that the parties didn't want to perform. The other limb on which one could seek to rely is illegality. Now, illegality arises in a situation where the contractual obligation is actually unenforceable, not because of something the parties have done or want to do, but because there's a positive prohibition from performing it. It would be illegal to do it. But again, a narrow doctrine. You've got to precisely identify the scope of the prohibition very carefully. And the important point is also you may have a difference where you have the contract being governed by English law, but the performance takes place in a jurisdiction where there's a different sanctions regime. Normally under English law, you would look at the place of performance, not the place where the contract necessarily was formed, or the governing law. And then also the doctrine operates only prospectively, so it doesn't entitle the party that's affected to recover sums that have already been paid. So those are two external ones. The final limb that one can be thought about is the actual operation of the contractual terms themselves. So it's well known there's no duty of good faith in English law, but there are two strands that could be brought to bear. The first is one might try, again, difficult, to show that the contract was some sort of relational contract. The courts are generally very reluctant to find the existence of relational contracts, but relational contracts do put different and more onerous obligations on the parties. The second is, of course, there's the so-called Braganza duty, which relates to the exercise of contractual discretion, where you have to do that honestly, in good faith, and in a manner that's reasonable, not irrational, arbitrary, or capricious. Again, the courts generally are reluctant to impose a Braganza duty. It's going to be very fact and very context specific. But those are all considerations that you could try to bring once, if you discover that you haven't got a force majeure clause, or you haven't got a force majeure clause that works, and there's otherwise no specific contractual provision. Those are the sorts of considerations that you have to take into account. And of course, as I say, and I stress, these are always, when the courts look at them, they always become very fact specific, they become very context specific, and it's fair to say that generally the courts do not like using them as a means to undo a bargain that may just have turned out to be worse for one party than the other because of events that have come along.
That's a very important point. Also, I noted, I got that in many cases the law does not give a single clear answer, but businesses still need to act. Mariam, let me come back to you. It's very important. We need to share some practical insights here. If you had to advise client today, what should they be doing right now to manage their contractual risks?
Well, that's an important point. Early legal response. And don't mix that with early escalation. The purpose is not to rush into invoking the harshest contractor rights. The purpose here is to protect the company legal position while keeping the business on the go. In practice, that means three points. First, management should document thoroughly and prepare a clean internal risk assessment for decision makers. Second of it, communication. They should communicate with financer, partners, and counterparties, and that should happen very early and a disciplined way. Yeah. So the business preserve credibility and negotiation position. Third, I'd say companies should try to maintain balance in long-term contractor relationship, especially where continuity of performance is still not. A well-managed legal response will not only strengthen the legal protection, but also financing confidence, operational equity, and stakeholders' trust. So the balance is this: protect rights early, document carefully, communicate, and avoid unnecessary escalations unless that is truly needs.
Unnecessary escalation. This is very practical. Mariam, thank you. Francis, I want you to build on that. How should companies be using their contractual rights in practice, particularly when considering force majeure or termination?
Thanks, Amit. I mean, I think if you're looking to protect your position and you're under a lot of pressure and you think there's something that might be akin to a force majeure situation, I would recommend 3 things, and they all need to happen at the same time. And the first, unsurprisingly, which I've already touched on, and it's a non-negotiable, is a granular analysis of every affected contract, not at a high-level summary level, but clause by clause. Look at what are the qualifying events, what's the threshold, is it prevention, hindrance, or delay, what are the notice provisions, and what are the evidential requirements. I mean, if you take FIDIC in construction law, for example, you've got, I think, 14 days from awareness of the event, and if you miss that, regardless of how good your substantive merits might have been, you're likely to lose. Second, issue protective notices early. In my experience, and there's some case law on this, courts and tribunals generally accept contingent or precautionary notices pending full legal assessment. So a cautiously and carefully worded notice costs nothing, but a missed deadline can cost everything if it's a condition precedent to your ability to claim relief. And again, take care how the notice is framed. If a badly drafted declaration of force majeure that overstakes a position can itself amount to repudiatory breach, as I identified earlier. And the third point is a simple one that Mariam's already touched on, which is document contemporaneously. Every operational decision, every mitigation effort, every communication with suppliers, insurers, counterparties, all of its potential evidence for a dispute. And if a dispute reaches arbitration in, say, 18 months or 2 years down the line, it's that contemporaneous paper trail that will persuade a tribunal or a court that your client took, for instance, reasonable steps, and that the causal nexus between the event and the non-performance was real. And this can be particularly relevant where you've got a trader, for example, or whoever it is used to picking up the phone. That's fine, but make sure you back it up with an email chain, because you don't want to be 2 years down the line saying, oh, I made a call on this date and this is what we discussed. It's much harder. It makes your burden a lot more difficult when you're trying to prove your claim.
Fantastic. That's very helpful, Francis. Especially the point that exercising the contractual rights require careful timing and judgment, not just legal entitlement. But in practice, many of these decisions are also shaped by external constraints, particularly around payment, counterparties, and financial flows. Drew, let me bring you in here from a practical standpoint. How should companies be managing sanction-related risk in real time, particularly when dealing with payment, counterparties, and the ongoing obligations?
Well, first of all, I think one thing I would look at is you're looking at it from the standpoint not only about avoiding a dispute, but being ready when this dispute happens. And the good news is that often what you want to do for one is the same for the other. And so first of all, I think when we need a lot of this will mirror some of the things that Francis was talking about, we were doing internally, but now you're dealing with the external situation of sanctions. And so again, I'd say the main thing to say here is nuance. We need to work through carefully what sanctions regime is said to apply, what contractual obligation is affected, and what is the real issue. Is it illegality, or is it really a commercial risk? Or is it force majeure because there's some sort of temporary obstacle? Or is it some combination of those? And it's very important to make the proper assessment of that, because the way you react to it is going to affect your legal position. Similarly, on the question of causation, when we're dealing with these external obstacles that enter into sanctions, when we're talking about the licensing, or when we're talking about sanctions, we're also dealing, as I mentioned before, with licensing regimes. We also may be dealing with situations, it may affect payments, it may affect export controls. Is the issue really the sanctions? So, as I mentioned, the RTI case before, dealing with payments, there could have been alternative methods, paying in euros instead of dollars, but the contractual position was that the party did not have to accept performance in the alternative currency. I've been dealing, I was in an arbitration recently where one of the issues that arose was the export of Microsoft Windows that was necessary for a certain an engineering project, a construction engineering project. It might seem something simple off the shelf, but the party that had to deliver it, it was contractually required to deliver it, couldn't do so because of sanctions. And the issue arises at that point is there an alternative? So documenting your efforts to solve that problem can be important, because if you haven't made that effort, or if you don't have the specialist expert evidence or of what can be done as an alternative, that may be an obstacle in your dispute. And then secondly, the fact that whether you have attempted or not can be an issue. Does your contract have a, say, a provision for variation orders or a variation clause where parties can are actually required to seek an alternative route that can be deployed, and have you complied with that? So all of these issues can be decisive for the outcome of your dispute. And I would echo what Francis had said, is you want to have that documented. I can't, so many cases I've been involved in where you come up, well, the client says, well, we did call and we did find out about that. Well, where's your evidence? Oh, then you get a sort of a half-baked email. And that if that had been bottomed out contemporaneously, you'd have a very good piece of evidence. But now you're left a few years later trying to prove something where you have a very thin record. So if you're doing both of those things, it's going to help you place you in your best position. You've seen that you've exhausted those things in dealing with the dispute at the time, but you'll also be ready if it does go to arbitration or to the court.
That's great. Evidence, yeah. Just very important one. Maybe we notice that a lot of clients and companies that they are not taking care about their evidence. And I like the point that managing risk in real time often involves constraints that sit beyond the contract itself. So if we take a step back from individual actions, Iwan, let me come back to you from your perspective. Are there any additional consideration businesses should be thinking about at this stage, or any key points would you highlight as we bring this discussion together?
Thank you. I think the thing I would want to emphasize, which both Francis and Drew have dealt with, is this issue of evidence and making sure that you have the right paper trail. And I say that because, in particular, if you're going to seek to rely upon frustration, for example, the whole essence of frustration is it has to be something which is, performance has to be impossible, illegal, or radically different from that which was originally undertaken. But critically, there is a line of case law which makes absolutely clear the fact that performance is more onerous or more expensive is not of itself something that can frustrate. Why does that matter? It matters because, of course, there is always a temptation and a danger that if you have a contract which is actually, having entered into it, you wish with hindsight you had not done for other reasons, there is always a temptation to use a circumstance such as the current one to get out of those obligations, and in fact to seek to rely upon a doctrine such as frustration. So that's why it's really important to be able to show and to evidence exactly what you're doing. So that's the one point I would say. I think the additional legal consideration, the most important thing, is make sure you're evidencing and keeping records of what you're doing as you're doing it. I think there's plenty of case law now, which has grown up indeed in different jurisdictions in relation to how COVID affected contractual performance and contractual alterations and so on and so forth. And when one looks at that, it's clear that for perfectly understandable reasons, decisions are taken in real time are not necessarily always fully documented or documented as completely as they could be. You see that time and again. The same thing is also true, I think, when you look at what happened during the financial crisis, 2008, 2009. So the key thing is really to make sure that you are building up your evidential portfolio, so that if you do ultimately end up in dispute, you can show the steps you tried to take and with what effect.
Make sure you're building your evidence portfolio. It's a magic word again here in this webinar. Thank you, Gwen. That's a very helpful way for bringing that discussion together. I want now from all our panelists, if each of you had to give one immediate recommendation to a company operating in Kuwait or Gulf this week, what would be? Francis?
Thanks, Ahmed. Do you say if I can give one piece of advice or one condition, you mean?
Yeah, to one recommendation. Just recommendation, advice, but to do it this week.
If it was this week, I'd riff off what Ewan had just said and said, almost at a commercial level, as soon as you're faced with a dispute, tell your people who are running those operations to switch track. Because again, in my experience, loads of them spend a lot of time on the phone and say, as soon as you get anywhere near a dispute, start putting everything in writing. Almost adopt a different personality for that period until it's resolved. That would be my piece of advice.
I like it. Drew, what is your 2 cents here?
Well, dealing with the specific sanctions context, I would say if you do run across a sanctions issue, first of all, do not throw up your hands, do not get discouraged. You need to get down to the nitty gritty, the details of your dispute, and carefully work through your potential alternatives, your potential solutions, and your contractual position. It is not necessarily the case that the issue cannot be overcome, and very often, particularly in this environment where you're dealing with sanctions clauses, you can work a way through it. But don't assume that it's frustrated, but equally don't assume that if you don't have a sanctioned party, there's no obstacle. But you have to go down to the detail and the nuance.
Thank you, Drew. Mariam, do you have anything to add?
I would say I'd immediately go back to the contracts, stop the assumptions with a plan.
Very practical. Iwan?
Well, I will build on that, and I'm bound to say this, I suppose, as an external lawyer. Go back to the contract, but get somebody else in from outside to look at it, because you may have lived and breathed the contract for many years. Sometimes an external perspective can be really valuable, both in terms of finding things for you to pursue and to rely upon that you may not have noticed, also spotting potential vulnerabilities you may not have identified. And it is something where it's much easier to do when you're coming from the outside than when you've been living and breathing something. So I'm sorry, it sounds like a type for business. It's not. I genuinely think it's really helpful in these very difficult situations.
I love as well. During the webinar, there are a number of key takeaways for businesses operating in this environment I have drawn up. I want to share with you guys. One, act early. Don't wait for disruption to materialize. Second, your contract is only as strong as how you use it. Sanctions are a commercial risk, not just a compliance issue. And not every situation has a clear contractual answer. Align legal rights with commercial decision. In these environmental contracts don't fail because of events, they fail because of how those events are managed. Now we come to conclude to our webinar for today. Okay, to you, Paula, we have concluded.
Thank you so much.
Thank you, Shiraz and Ahmed and the speakers. I would suggest if whoever asked the questions, if we have a little bit of time, maybe we can go over. And everyone else, thank you so much for being part of the event. But I think there is one very specific question that I think many would be very interested in, which is the current situation in the Gulf. So somebody sent, how does the legal definition of force majeure apply to our current situation, given that while we work in Kuwait, while the work in Kuwait hasn't ceased, the partial disruption makes full contractual compliance practically impossible. And I'll add a little bit to that. Sometimes it can be with, as I mentioned before, bringing workers in to finalize a contract. For example, you have a construction site, maybe you don't have enough manpower to finalize on time, or a lot of people did leave because of the war, or they quit their jobs, and it's virtually impossible to fill in those positions right now because commercial visas are not available. So how would force majeure come into definition in that case?
Do you want me to pick this one up, Amir?
Go ahead.
Or I can start again from an English perspective. So for the first question is, look at your contract and see whether it's governed by English law or Kuwaiti law, for example. If it's governed by English law, the first thing you're going to need to do is look at the force majeure clause. And when we talk about performance, we're talking about specific obligations. So you're going to need, don't look at the contract as a whole and say, oh, there's some problems with my contract as a whole. You're going to need to say, this specific obligation that I'm required to perform is rendered, let's say, impossible by virtue of this specific event, which causes the impossibility. So you're going to need to sort of granularly go through the obligations that you're required to do. And if it's a case of like, you need to, or it's impossible because you can't get the requisite number of workers, you're going to need to identify that as either an express term in the contract or an implied term in the contract and say that's impossible to perform. I hope that helps a little bit from an English law perspective.
Thank you, Francis.
Let me add something here for you, Marius. It's very important. Majeure is already related and under the law, and it's already defined, and its provision is clear, and there's many judgment make it clear for the government. There is no specific termination to have to be issued or but the only thing that we notice that Kuwait Oil Petroleum Corporation that announced that the force majeure because they are stopped for producing the oil. This is only a government authority that announced about the force majeure. But another thing that I want all of you to think about it. Force majeure is no longer just a defense clause. It is like a risk management tool that need to be actively engineered into the contract. And now you have to redefine. And if you see, as we reply to Rajesh in his question, if you want to add another thing to not just the word, not just act as a god, not act as a government, you can add supply chain disruption right now, sanctions and trade restrictions, payment blockage. Also, sometimes you can like situation like now, logistics and transportation concentrate. All this could be if you are defined and agreed about that, and you have to see specifically about your contract, not the others one. And it's not easy for the government or any official to announce that there is a force majeure, and because it's a depend about what is your commitment, what is your obligation in the contract, if it's you can do it or not. Hopefully, I make this clear to you, Paula. Again, I think we are already past our time, and if there anything else we can answer.
Thank you, Ahmed. And if there are any other specific questions, please feel free to share them with us by email, and we will share them with the speaker so that we can get back to you with better answers if need be, okay? Again, thank you to everyone who participated in today's webinar, and we hope that you continue to stay safe, and we look forward to seeing you soon at a better time.
One thing I forget to add, Farouk, I think sharing the advisory notes that Dar Muhammad is already prepared for these circumstances, it's a good guidelines. And I think also Mackinton Chamber is prepared in a good article, especially for the Middle East here. We will share both of them for you so you can extend that spirit with all our friends here. It includes a lot and very practical insights about how to deal with the right situation right now.
Thanks very much, guys.
Thank you. Have a good day.